I've written an article about an issue that is the subject of growing debate in the antitrust community in the state of California. The issue is whether or not the practice known as minimum resale price maintenance is still subject to the per se rule in violation of the Cartwright Act here in California. Now let me start by explaining briefly what vertical resale price maintenance is for those of you who may not be familiar with that concept. Manufacturers, for the most part, distribute their products through distributors and dealers, and the dealers then resell to the consuming public. Now, manufacturers oftentimes have more than one dealer, in fact, most of the time, and those dealers oftentimes compete with each other in connection with the sale of that manufacturer's products under the manufacturer's brand. The question that arises sometimes is this. The manufacturer would like to have dealers invest in personnel, training, pre-sale services, and post-sale services in connection with the retailing of their products. Retailers who do that often complain that they have to invest a great deal of money in that manufacturer's brand when providing those kinds of services. And dealers are most concerned oftentimes about competing dealers in that manufacturer's brand who do not make that pre-sale and post-sale investment, but instead free ride on the activities of the competing dealer and then discount the product by siphoning off the consumer who has learned about the product from the other dealer. And manufacturers oftentimes receive complaints about those discounting dealers by the manufacturer's other dealers who are in competition with them. So what manufacturers have wanted to do, going back to 1911, is impose a requirement upon their dealers that they must resell their products to the consuming public at a minimum price. For example, the manufacturer may say, I want to see my dealers reselling at no less than $100. You can sell at $150 if you want, but you cannot sell at $99 or below. And that is an activity that is aimed at making dealers profitable enough so they will invest in these pre-sale and post-sale services and other activities. It also eliminates the problem with the discounter, because if the discounter does not sell at $100 or above, the manufacturer will terminate the dealer. Now, that's what's known as minimum resale price maintenance. It has, until 2007 at least, for almost 100 years been viewed as what's called a per se violation of the antitrust laws, both the state laws and the Federal Sherman Act. Per se liability, of course, means that it is a practice that does not require economic evaluation or any study of the impact that it might have in the marketplace. It is viewed as an activity that always, or almost always, restricts competition and has no redeeming quality whatsoever. That changed in 2007 when the U.S. Supreme Court was asked to decide a case that is well known in the antitrust community by the name Legion. And what the Supreme Court decided was that as of 2007 and coming forward, vertical resale price maintenance was no longer going to be viewed as a per se violation. Instead, in most instances, the competitive impact would be evaluated under what's called a rule of reason. And the rule of reason, of course, means that the restraint is not a repulsive restraint. It can, in fact, have pro-competitive impacts. And under the rule of reason, the courts will evaluate the specific case-by-case net economic effects within a market and the pro-justifications for the restraint. The question then has been resolved at the federal level, and the per se rule no longer applies. But that's not the end of it when clients are wondering whether or not they can or should, from a legal standpoint, implement that type of a policy, because they have to take into consideration individual state laws as well. In other words, the federal Sherman Act does not preempt the states from enacting their own legislation, which could be contrary and often, and in some instances, I should say, is viewed as antithetical to the Sherman Act reasoning. California, for example, has what is called the Cartwright Act. And the Supreme Court in California, going back to 1978, enunciated in an opinion by the name of Mayland that under the state antitrust law, vertical resale price maintenance was also per se unlawful, just like the federal law at that time. The problem is that Mayland was decided by the California Supreme Court when the U.S. Supreme Court held and continued at that time to hold that resale price maintenance was a per se violation. And Mayland was a case that ostensibly has for its underpinnings the assumption that the California statute is harmonized with the federal Sherman Act, so that whatever the federal law is also the law under the Cartwright Act. Now, there's some question about whether or not the Cartwright Act is in fact interpreted or to be interpreted in a different way following the Legion decision in 2007. So the question and the debate that remains and is really heating up, if you will, today is whether or not the Mayland decision is still good law and controls in California. The fact of the matter is that is not a closed question. It is not there is no clear answer to that at this point. Two courts in April and May of this year went the other way. They moved in opposite directions, I guess I should say. A Los Angeles Superior Court trial judge found that Mayland was no longer controlling because it is outdated and it was based on what is now repudiated federal jurisprudence. A federal district court, however, in this same time frame, just recently in May, decided the other way, went the other way. The court found that Mayland was good law, it does control, vertical resale price maintenance is per se unlawful pursuant to the Mayland decision, and went on to say that it does not appear that precedent is going to change. The fact of the matter is precedent is already changing because we have these two competing decisions at the trial court level, and yes, it's true that the trial court does not issue opinions that have any precedential value. What it does suggest is that this issue is now a live issue. It is being debated in California by the antitrust lawyers here, and it now remains to be seen whether or not the Mayland decision will survive or whether it will be reevaluated and perhaps changed. So the question then is, if you are a manufacturer who wants to consider a resale price maintenance program for the reasons that I've just suggested, you're okay under the federal law, but you are not necessarily on solid ground in California. That's not to say that the court will find that it is per se unlawful and continues to be once the issue has come to the court, but what is clear is that the lower courts are now beginning to reevaluate that, and at some point in time, in the not too distant future, I would expect that the California Supreme Court will be asked to decide whether or not to bring the Cartwright Act into conformity with the federal Sherman Act on this issue, or not to do so, which they are free to do. I can tell you that the California, I came from Illinois, that's why I got a little confused there, but I can tell you this, the California Attorney General takes the view that vertical resale price maintenance is still per se unlawful under the Cartwright Act in California. The Attorney General, I think it's fair to say, will suggest that the Malin decision and some of the other precedents in California that dealt with this issue need to be re-examined, but their current position is that it is a per se unlawful violation until the higher courts decide otherwise. And they have brought, the Attorney General has brought actions against companies. Those actions are as recent as 2010, 2011. The court did not decide whether or not the Malin Act applies to, or the Malin ruling rather, applies to the Attorney General's position today, because those cases were settled pursuant to consent decrees. But there is a great debate. It is an ongoing debate, and right at the moment, it is a debate between two different courts. Although they're not debating each other, they're simply debating the philosophical underpinnings separately, and all of the lawyers in California who deal in this antitrust area are joining that debate. I've written an article on this, and I went into some fairly comprehensive detail on these issues and the positions that are taken and the history of the and evolution of all of this. And we are following it. It's an issue that is not going to go away. It is going to expand, and I will plan to update you with that when the time comes.